Good morning, everyone. My name's Jim Masterson. I'm head of global litigation at MasterCard. Ken Daly and I will be speaking about litigation developments in Europe, which is beginning to adopt the US-style class actions, including, importantly, the presence of litigation funders in Europe, because it's created, I think, some unique issues and really major policy concerns. I'm going to try to provide the practical in-house perspective. Unfortunately, MasterCard, my company, has been out front on this topic. As you might have seen several years ago in the press, we were the target of probably the first and certainly the largest class action in the UK that utilized the UK law. Fortunately, we came out unscathed in the sense that we defeated the request for certification, although that's still under appeal. And probably the highlight of that experience, unlike my typical US experience, is we got a nice check from the litigation funder for our litigation fees. So that was the one positive of the experience. Ken will provide, as a Brussels-based practitioner, and he'll provide a European perspective. I'll try to set the context for MasterCard's experience in the UK to give you some perspective. In 2015, the UK passed what was called the Consumer Rights Act, which really allowed for class action, opt-out class actions, typically in the antitrust competition law context. The proponents of that legislation touted it as benefiting consumers, enabling them to obtain monetary redress for alleged antitrust violations. And there were many assurances that they would avoid the excesses of the US litigation class action culture. So let me tell you about my experience. So it's July 4th, 2016. I'm awoken by calls from our comms people in Europe who've indicated that Quinn Emanuel has released a press release that they're bringing a class action against MasterCard. My first thought is, why are they a US-based firm? Is this a US issue on July 4th? It turned out that, of course, Quinn had established a shop in the UK to take advantage of this law. It went on, the complaint that was filed against my company was based on alleged class of 46 million consumers over a period of 16 years from 1992 to 2008, alleged damages of 14 billion pound, or 18 million US at that point, I think, in conversion. The claims were every single purchase made at any merchant who accepted MasterCard, there were damages. Not only for MasterCard cardholders, Visa, Amex, cash, check, every form of payment. That was the alleged damage. So I guess my perspective is certainly the excesses of the US system and then some transferred. I don't know, Ken, what's your European perspective?
Well, thanks, Jim. I think from the European perspective, what you've just described is the essence of the US class action system. And the argument that US class actions will not come or have not come to Europe, I mean, is demonstrably false. I think your case really shows that. And unfortunately, it's not the only one. I think you have the bad luck to be one of the first identified in a case like that. But there are others in the pipeline, many others in the pipeline. Another one, as we were discussing earlier, also claiming 14 billion pounds in damages, again involving US funders, US law firms. So the idea of the US class action, unfortunately, has come to Europe. Now, Europe has taken this on the promise that US-style class actions would never be welcome, and we're going to do this in a European way. We're going to do this in a fashion that takes all of the benefits of class actions but accepts none of the risks. And the way that is being approached in Europe right now is that some individual countries are doing it on their own. The UK obviously is somewhat out front and has put forward this law. but 19 of the 28 member states of the European Union now have a class action system of some kind. This has led the European Commission and the European Union to think, hey, we've got to create an umbrella system that's going to cover the cross-border cases and cover the bigger cases. We need to get control of these 19 different competing strands. And so they've just, in the last few months, made a proposal for a European class action system. It is, in many respects, as I think Lisa mentioned this morning in her introduction, in many respects, it's worse than the US class action system. Although the wrapper says this is going to be European style and it's not going to bring about US class actions, as we've seen, some of these claims can prove to be a little bit false in reality. So maybe we could spend a little time just thinking through some of the sort of main aspects of that and also your experience, Jim. And I thought we could maybe try to talk about this by addressing just three topics, each of which I think reveals something important about class actions. The first question I thought we might discuss is who can take actions. The second is what kind of actions can they take? And the third, maybe most importantly, is where does the money go?
Yeah. Follow the money.
Yeah.
So no, that's a great three topics. So I think on who can sue is the question. The experience obviously I had in the U.S. is we have nominal plaintiffs, class representatives, but it's really the contingent law firms that are behind most of these cases. But at least from a U.S. perspective, when you're opposing class certification, defendants are able to take discovery of the class rep. We're able to get both document, deposition, discovery, and often that proves very useful in opposing certification. How would it work under the European system?
So under the European system, what they have in mind at the moment is that it will not be possible for consumers to sue themselves in their own name through a representative plaintiff or anything else. Instead, they will, if you like, outsource the ability to sue to what they're calling a representative entity. That could be a consumer organization, it could be an ombudsman, it could be some form of, some sort of third-party actor, including ad hoc entities set up in order to take claims on behalf of consumers. Now, to some extent, that's good. It's better because if you identify who can sue, you can control it. The idea is that each of the member countries will have an ability to license entities to take actions on behalf of consumers, and they're proposing at the moment a number of criteria which look on their face to be helpful. For example, that the entity would have to be a not-for-profit entity, which sounds like a great thing that could draw a lot of the bad incentives out of litigation. Unfortunately, however, the legislation as it stands is hopelessly weak in terms of enforcing even its own safeguards. While the idea maybe is solid, there's nothing at all to stop a law firm or a third-party funder or some other kind of entity setting up their own not-for-profit entity, the first act of which will then be to hire that law firm or hire that third-party entity for whatever amount of money they want, for whatever fee system, for whatever cut of ultimate damages. So they've taken some steps towards some safeguards, but it's hopelessly inadequate at the moment.
No, that's tough. And then what cases can they take is the next topic. And, obviously in the U.S., the plaintiff bar it's a broad range of cases, whether securities, antitrust, product liability, data protection, consumer fraud. And then separately, we have the statutory class actions, like particularly the notorious Telephone Consumer Protection Act. What type, and our experience in the UK was a competition law case. And I think, although broad, the statute, I think that it was limited into those type of cases. What is kind of Europe looking at in terms of the breadth of the potential claims?
So Europe started with the idea that it would try to identify all of the laws in Europe that come from European legislation that create some kind of consumer rights. So they've identified a list of 59 separate laws. They cover everything from medical devices, pharmaceutical products, environmental, securities, online commerce, you name it, the list goes on and on. Anything really involving some kind of an interaction with a consumer is probably going to be covered by one or more of those laws, including, I should say, data privacy. I know we've heard a lot about data privacy this morning. And the idea is that if a breach of one of those European laws is identified, then the mechanisms within the proposal will be available. Now, there are lots of different mechanisms, but I'll just mention just one of them, just to illustrate how peculiar it is, the mechanisms that are being suggested. There's one kind of action being proposed where somebody decides that the amount of money involved per consumer is small, a concept is not defined, then it will be possible for a representative entity to take an action on their behalf without any mandate from any consumers. So the law actually says no mandate may be sought, meaning this is not an opt-in type of action, nor is it an opt-out type of action. In fact, the action would be, it'd be possible to take the action for those consumers, whether they liked it or not. So even if you had a group of consumers saying, hey, we don't agree with this case, we think you're doing this for your own reasons, there would be no possibility for any consumer to say, I want no part of it, which just seems wrong on so many levels. The most peculiar part of all, though, is that in those cases, if an award is made to that entity, the money will not go to consumers. Instead, it will go to a public purpose, which is not defined. So who knows whether that public purpose is, the entity itself, or whether this is just a very broad type of CPRE or something else. But the legislation simply doesn't address it. So it's very concerning, because obviously an action could very easily be taken by a law firm or a funder in the hope that there would be, in fact, no consumers at all to claim money, but that they would take the lion's share of the proceeds.
Amazing, yeah. So, and the money is probably the third topic. Follow the money, litigation funding, and our experience with that. And in the MasterCard case, it was really eye-opening. Because we were able to get access to the litigation funding agreement, although there were numerous disputes prior in terms of the scope of that. So the first versions we received, because they were required, the court needed to review them, were quite redacted, and subsequently we were able to, through the litigation process, to fight and to obtain kind of the key terms, the economic terms. And I think they really do highlight some critical, just our experience, some critical policy issues that are raised by these actions and the role of litigation funders. Because kind of what you almost have is the potential for a perfect storm. You've got, there is the lack of contingency fees in Europe, but coupled with the presence of litigation funders, creates the potential for extremely speculative claims to be litigated in the future. In the US, we're typically dealing with real parties of interest being the class action law firms. Those law firms, have, time is money for them, so they do have some interest in evaluating and reasonably assessing the viability of their claims. On the other hand, in Europe, the cases that we seem to be facing with litigation funders are principally funded through them. So you have a separate law firm whose fees are being reimbursed by the litigation funder. In our case, a critical piece of trying to oppose certification was that what we claimed was a conflict between the class representative and the litigation funder and the class. The litigation funding agreement required that the class representative ensure payment of the funder's investment return, which conflicted with what we viewed as his obligation and duty to max amount of the distributed damages to the very class. The funder's return in our case was going to be based upon a percentage of undistributed damages. And we argued, and the presence of that funder created the incentive for the absurd class that was alleged in our case. 46 million people from 2002 to 2008, nearly, the odds of claims being made were very low. the funder was going to get the return on that. In our case, the potential outsource of funds from the funder was capped at 40 million, although really it was capped at 10 million because there were multiple ways that they could get out if it exceeded 10 million. The potential return was 1.5 billion if their claims had succeeded. And what does this create? Such a massive return means that there's an enormous risk of speculative claims being litigated in the future that are backed by litigation funders, because it's like the lottery. They got to only hit one for the return to make sense for them. And what does that mean for both courts, consumers, and corporations? The court system will be overburdened. Consumers aren't going to be benefited, and corporations face both the reputational and the communications and the investor relations issues around the noise around these speculative massive claims being filed. I guess from your perspective, is there anything in the current kind of thinking in the European context to try to address this litigation funding issues?
Well, the EU authorities are, I suppose I could say, they're beginning to wake up to the risks of third-party litigation funding. They have put some provisions in this draft law that I mentioned, which will require transparency and try to limit the amount of control that funders will have over the conduct of the litigation. But again, it just doesn't go anything close to far enough. They haven't truly appreciated the size, the scope of the problem. It always strikes me as odd that in Europe, lawyer contingency fees are prohibited in pretty much every one of the 28 jurisdictions. And the rationale is that if lawyers have a stake in the outcome of the litigation, they're going to start acting in their own interests and not acting in the interest of the consumers. And you're dealing with licensed attorneys subject to bar supervision, subject to all kinds of fiduciary duties. So in Europe, that's not okay. But it seems to be just fine for a hedge fund to provide exactly the same type of funding, the same kind of guidance or initiation of cases for a percentage of the outcome, and there doesn't seem to be the same kind of concern about what hedge funds or other litigation funders might do or how they might steer cases. So there seems to be a lack of joined-up thinking in that regard. So the EU is beginning to think about it. They're going to do some more work on this later in the year, but I think particularly in the UK, the examples that we're aware of are showing that really it's the funders, even in some cases more than the law firms, that are actually driving the litigation for exactly the reason that you mentioned. And I'm really taken by what you said about the funders being funders structuring their arrangements so that they get paid out of undistributed damages, meaning that the less money that goes to consumers, the more money they make. I mean, if you think about that as the logical purpose of their involvement, then you really see what's going on. And you see exactly the same thing in another very major case that's just been filed in relation to trucks, and the entity that has been set up to take this litigation, its first act as a legal entity was to register a charge in favor of a funder, and the charge, like a mortgage, says that basically all revenues of this entity for all time shall first go to satisfy demands of our backers and funders, and all payments to consumers shall be secondary. So it's almost burned into the logic of their organizational structure. So in terms of where all this is going in Europe, the European Commission has made the suggestion. The European institutions, the European Parliament and Council are looking at it now, and there's a very healthy debate going on right now about the pros and cons. There's a very active and very engaged pro-class action lobby that has proved very influential in Europe, and a lot of this is again backed by US funders and law firms who of course want all of this to happen in Europe. And there are, frankly, not enough voices on the other side. ILR has been doing a fantastic job in Brussels, engaging with the European Commission. But I think it's right to say that more help is needed. So if there are if there are any of you in the audience that are interested in this discussion and debate, then you really should contact Lisa at ILR, because they're really right at the coalface right now of trying to stop this before something really dangerous gets adopted in Europe.
Time is now.
So, and the time is now,
now.
and time is now. So I think we are out of time. So
Thank you.
thank you very much.
Thank you.
Everybody's